Sarah, we have a title, Multi-jurisdictional disputes, the good, the bad and the ugly. And in the context of civil fraud and asset tracing, I think you and I had the same reaction, and then it leans pretty neatly towards the so-called nuclear weapon of the English courts, being the freezing injunction.
Absolutely, Charity. At King & Spalding, the team has acted for clients in a number of cross-border fraud cases. These cases require a great deal of coordination, in our experience, with lawyers in other jurisdictions, and an overall strategy as to how to secure the best opportunities for recovery for the client. We've had a lot of success over the years, locking down billions of dollars for clients in dozens of jurisdictions using freezing injunctions, as well as other ancillary relief.
And in a variety of circumstances, right? I mean, you can get freezing injunctions at the outset of proceedings, the enforcement stage, and we've applied and secured them in support of foreign proceedings. So when the good, the bad, and the ugly comes in, I suppose the good aspect is what we've found has worked well. The bad is the potential pitfalls to avoid, and the ugly is kind of the battles, I suppose, that can ensue even after you've secured the relief. So with that in mind, what do you think are the good parts? What's the most important factors to a multi-jurisdictional asset recovery strategy?
So for me is complete the investigation stage thoroughly. Don't start things before you've got your ducks in order. For us, we always try and work with good corporate investigators who have good experience in asset tracing. Investigators will look to where defendants and their suspected proxies are, how properties are held, how assets are held, how they appear on public registries, what are the personal connections. It's amazing what you can do with a good kind of Instagram search. At the time when you're gathering this information, always have in your mind that you need to be able to use it. So, have the criteria of a freezing injunction in mind when you're setting this up. So, a few things to think about on that. Is the test of a good arguable case. That's what you're going to need to show to the court. A good arguable case is more than barely capable of serious argument, but it doesn't need to have a better than 50% chance of success, for example. A good arguable case, importantly, applies to all aspects of the case, and so that it is also related to the sum that you are freezing, not just kind of the legal tests in terms of defendants and where they are. In terms of the existence of the assets themselves, once your inquiry agent, your investigator, has given some good leads, you need to really interrogate those findings yourself. And not enough for a defendant, a respondent, to be apparently wealthy, or for you to claim that they must have assets somewhere in the world. The English court is going to want more from you than that, and there must be grounds for belief that there are assets on which the judgment will bite. One thing to note, whilst it's obviously easier where you have assets within the jurisdiction, within England and Wales, they don't necessarily have to be here. You have to establish links between the respondent and this jurisdiction, though the court will not start to entertain applications where there's no link at all. The other thing to have in your mind, and when you're talking to your investigators and looking at the evidence you have, is the risk of dissipation. The English court will need to see that there is a risk of dissipation. An unanswerable claim is powerful but not decisive. Evidence of an actual intention to dissipate is not strictly necessary, so that the bar does not go that high. But what you have to do is to show that the defendant is dealing with assets in a manner other than is usual or their ordinary course of business or life, which includes, for example, repeated failure to honour promises to pay. Again, this is a pretty high bar, although you don't have to show actual intention or evidence of an intention to do it. It remains that we have to show that it is out of the ordinary. The other thing I would kind of have in our minds is the coordination aspect of seeking injunctive relief across the world. You know, where you do, for example, have a kleptocrat who has means and law firms at their disposal, and you know, and corporate agents in offshore jurisdictions, you know, you need to be very, very well coordinated because they will be. And you need counsel in every jurisdiction in which you will move for injunctive relief. And it's absolutely essential that you tell the same story in every jurisdiction, because people are going to be looking to attack what is said, and therefore you need to be very organised. When we've done these before, where we've had 5, 6, 7 jurisdictions where we have found assets and we look to move at the same time, we've identified a home office team, or a hub, if you will. That's involved us in doing a lot of the drafting by a very tight team, sharing that with lawyers of the world, and adapting drafts so they comply with local law and local procedure. So, I mean, those are my kind of views, having done this for almost 30 years. I mean, Charity, you know, you've not been doing it as long, but you have been doing it, you know, a lot as part of our team. In terms of freezing injunctions in broad terms, we've spoken about the kind of the generalities, but there are variables which need to be considered in order to tailor the appropriate relief for your requirements. I mean, for example, what sort of freezing order are you looking for?
That's right. I mean, as you say, we talk about freezing injunctions in broad terms, but there are all of these different tweaks that you can make to the pro forma order that's in the commercial court guide, or the CPR, all of which need to be considered. And the first one is pretty obvious. It's what kind of freezing injunction. You will know that from just the kind of instructions you've received. The classic freezing injunction that we probably all think about is at the outset of proceedings, when you're going to file probably a case that concerns dishonesty, and are concerned about tipping off and dissipation, and they go hand in hand. But it's important to remember that a freezing injunction can be issued at any point in proceedings. So if it suddenly becomes clear that a defendant is about to remove their English assets from the jurisdiction, you can go for a freezing injunction. You can even apply for a freezing injunction after there's been a judgment or an arbitral award, even if the underlying proceedings didn't have a freezing injunction. But again, as is the case with all freezing injunctions, that doesn't give you a proprietary interest in the defendant's assets. What it does do is freeze the assets so that you can issue enforcement proceedings against those assets now that they're frozen. The third type is if you get a freezing injunction in support of foreign proceedings. And that is, you still have to show the good arguable case, you still have to show the risk of dissipation, all of these things. You also need to show that the facts would warrant relief if the substantive proceedings have been brought in this jurisdiction, and that the injunction will have some utility which is related to the foreign proceedings. Then you need to consider whether you'll be asking the court to grant worldwide relief or domestic relief. And I think sometimes the temptation is just to go for worldwide relief because it seems like you'll be getting more. But if the respondent's assets in England and Wales are exceed the maximum amount that you will be seeking, then the court won't be interested in granting you worldwide relief, but also it's not in your interest, because there's nothing to require a respondent to use assets outside the jurisdiction for its ordinary expenses, its legal expenses, its day-to-day business expenses, instead of using its English assets. Another consideration is if you could get a proprietary injunction, either hand in hand or stand alone with a freezing injunction. So that's where you have a claim to the assets themselves as opposed to potential enforcement against assets. And the bar for obtaining a proprietary injunction is slightly lower than the bar for a freezing injunction, in that you do not have to show the risk of dissipation. And the final consideration is whether you move ex parte or on notice. Obviously, if you go on notice, you don't bear the burden of full and frank disclosure. However, it's much more difficult to show to a court that there is a risk of dissipation if you've placed the defendant on notice of your application. And indeed, courts have found that an on-notice application completely undermines applicants' case on dissipation of assets previously. That's not to say it's impossible. There are examples of on-notice freezing injunctions that have been granted, but it's a trade-off basically between the full and frank disclosure and the risk of dissipation case.
Charity, I mean, in terms of other ancillary relief available in the UK and more widely, for example, we've had some great success with Norwich Pharmacal orders, applications and orders granted in offshore jurisdictions, as well as 1782 applications in the United States in relation to documents. Those are real tools in one's armory when one is attacking on all sides. Somebody who's hiding their assets, they can be tremendously useful. What causes things not to go so well? What for you is what looks bad in a multi-jurisdictional dispute?
Perhaps unsurprisingly, a lot of it is the inverse of what we said is good multi-jurisdictional asset strategy, and largely it arises out of a lack of preparation or a lack of coordination. If you are not acting in sync with your local council, with your advisors in other jurisdictions, there's a danger that if one moves first in one jurisdiction, you could tip off the respondent to move assets in another jurisdiction. So it's crucial that you've coordinated a strategy to move at the same time, if that is the plan, that you do move at the same time. And likewise with telling the same story to all the courts. If you fail to do that and you've moved ex parte, if you fail to tell the same story, you run the risk of a breach of full and frank disclosure. I would say if a fact is deemed material to bring to the attention of the court in one jurisdiction that has this concept of full and frank disclosure, it is sensible to raise them in every court where you have that burden. And that's just a matter of protecting yourselves to make sure that, as we say, you stay consistent, get your strategy right and get your timing right. And then that, assuming that all goes swimmingly, you should secure your freezing injunction relief in England and Wales or elsewhere. But then how can things turn ugly?
So, I mean, I sort of picking up on one of your points in terms of the different courts. I mean, it's very tempting for us as English lawyers to assume everybody does things the way we do them and the tests are all the same. They are not. Even if a country looks like they have a very similar system to us, they don't. And so it's really important, I think, to ensure that you have good local counsel, you're listening to your local counsel and you're adapting your drafts for your local council, but keeping everything, as you say, so that nothing material is lost anywhere at all. For me, ugly is ugly sounds as if it's a surprise, and actually it's not really. It is how these sort of cases tend now to progress. If you act for an applicant, you can expect a respondent to challenge your full and frank disclosure, and there are a number of cases in the English court now in recent years where that has been the case. You haven't told the court material things. That is pointed enough for where you're doing one case in the UK and there's only one claim. Where you're replicating across the world in various courts, you have to be very, very vigilant, because that it is a real danger for an applicant, that they will come unstuck, that they haven't given it proper focus in every jurisdiction. If you're acting for the respondent, you expect the applicant to challenge your asset disclosure. So as a respondent, you will give asset disclosure. The applicant will look at that extremely carefully. It will give rise generally to a number of questions. I've seen over the years respondents who give asset disclosure without proper care and attention, and that really you can be handing somebody the ability to really chase you then throughout the proceedings. Weaponizing full and frank disclosure is a trend. I think, you know, the duties upon us as lawyers on claimants, applicants, extend to material facts that the applicant would have known had they made proper inquiries before making the application. So it's not just what you know, but really it's what you should know, and what you would know had you made those proper inquiries. And I think a lot of applicants fail in that step, and that you can come horribly unstuck. An injunction obviously is not discharged for every omission, but a judge may discharge and then immediately order a second injunction if the first one doesn't quite work, if the omission was innocent and would still have been granted had the material fact disclosed. But the more serious or culpable the non-disclosure, the more likely the court is to set aside the injunction. And remember that, you know, not only do you lose your injunction, you know, you've already told them you've told your respondent that you know where their assets are. The freeze gets lifted and they are free to move everything, and it can be a real scramble then. So it's really important to get the injunction right and not have that risk that it's going to be set aside. Irrespective of whether the proceedings remain on an ex parte basis, there is a duty to return to the court if the basis on which it has granted relief no longer applies. So there is a duty on us as lawyers to keep monitoring the injunctions that we obtain. And, you know, those injunctions can last many years, unfortunately. And you know, you can't just rely on the fact that it was obtained 5-6 years ago and say it's still good. The onus is on you as the lawyer policing the undertaking for the claimant parties. In terms of weaponizing the asset disclosure, freezing injunctions are strictly construed, given the importance, obviously, of compliance. But the restriction on dealing with assets has a very broad application. So the default position is that you must give, as a respondent, you must give full disclosure. If there's a breach, a claimant applicant can apply for an order for cross-examination of the respondent as to their assets. It's the exception rather than the rule, normally only ordered where it's likely to reveal further assets or where the deficiencies are serious or significant. So it's a last resort, but it's very much, you know, it's not something that's super unusual. Given the penalties for contempt of court and how severe those are, you know, it results in a prison sentence, even though it arises from a civil claim. The pressure exerted on a respondent for breach of asset disclosure is very real and very significant, and can, you know, is intended to force good behaviour and compliance. The last thing I wanted to really touch on was appointing a receiver. If assets are likely to be dissipated or are otherwise in jeopardy and cannot satisfactorily be preserved by an injunction, it may be worth giving consideration to appointing a receiver. You can do so at any point in the proceedings, and that receiver receives, manages and deals with assets, and they are authorised by virtue of the order that puts them in place from the court. The receiver is an officer of the court, not an agent of either of the parties. It means there's a loss of control for the process for both sides. But I mean, candidly, it is more keenly felt by any respondent. Receivers are generally more intrusive, more expensive, less reversible than an injunction, but it is always something to be borne in mind in particular circumstances. So, I mean, Charity, I've gone on a long time now. You know, we've talked a lot between the two of us on injunctions and what we've seen as being good and what we've seen as bad, and, you know, the plain ugly. If you had one thing you wanted people to remember from what we've talked about, what would it be?
I think it's the get your planning right and get your timing right. Have your good central team and ensure that you're coordinating with all of those. I don't think that's one thing, but that's what I'd want people to remember. What would you say?
Yeah, I mean, I agree. It's you know, it's having that planning, it's having the central hub, and knowing your case and making sure that you're locking down assets globally. We talked about strategic considerations. There are so many tools at your disposal. you know, that really, if you plan properly, I think, you know, those can all be well used.
Thank you very much for your time, Sarah. It's been a pleasure.
And thank you, Charity. We've worked together for many years, and it's, you know, it's always interesting to have these debates.